Welcome, everyone. This is the Data Chronicles. I'm your host, Scott Loughlin, and here are your data points. Today, we're going to talk about cybersecurity, but a specific angle within cyber. We're talking about data breach litigation. In particular, what happens when there is a data breach that's announced publicly? What happens in the courts? How are lawsuits being filed following that particular incident? And how are we seeing our clients respond to those incidents? I'm really happy to be joined today by two of my colleagues, Allison Holt Ryan and Adam Cooke, both of whom are experienced cyber litigators and my trusted right-hand partners as I work with organizations in responding to data incidents. Welcome, Allison and Adam. Allison, let's just jump right in. Maybe I can ask you just to give the audience a perspective on how you would describe the current state of data breach litigation.
Active. I would describe it as very active. These cases really started what we consider to be data breach class actions or data breach MDLs back in the 2013, 2014 timeframe on a way that really started to impact our clients after the data breaches of a couple of big retail organizations. And then thereafter, there was a couple of big breaches of healthcare organizations, and there were class actions after those. And then Adam, I'm curious if you agree, but it felt like we had a lull there for a couple of years. And then I would say that 2023 has come back with a vengeance. I saw a chart the other day that was showing the number of data breach litigations that had been filed going all the way back to 2013. And the numbers in 2023 quadruple the cases that were filed a couple of years ago. So what do these cases look like? What are we talking about? Generally, what we're talking about is following a data breach. So an incident where the PII or PHI of a company's customers or clients or members is exposed, class actions or other litigation filed after that data breach. Those claims generally, in our experience, get filed around somewhere between 30 and 60 days after the data breach is discovered by the company. And you might ask yourself, why 30 to 60 days after? And that's because Scott's side of the house is helping our clients provide notice publicly 30 to 60 days after these incidents. And so that's when these incidents generally become public. And when they become public is when we start to see plaintiffs' firms file these cases. Adam, I'd love for you to jump in here, if you don't mind, to chat quickly just about the types of claims we see, because you and I have been doing this for a long time, but I consider you to be the real guru of the claims that are in these cases. So what are you seeing right now as the claims that are filed?
Yeah, I think there's been actually a pretty consistent basis for these claims stretching back from 2013, as Allison was talking about, up to the present. And not surprisingly, one of the core claims in almost all these cases is effectively a type of negligence claim. So the argument is, hey, the organization that went out with notice about a breach should have been doing something different and better to protect the data. And if they had, they wouldn't have experienced the breach, and therefore they should be held liable for that. In addition to these kind of core negligence claims, I'd say that there are some others that we see very frequently. One is consumer protection claims, and these often hinge on representations or purported omissions, so failure to disclose something about a company's data security. And plaintiffs in these claims are often looking for statements that companies have made on their website, such as in a privacy policy, or statements they made in some other public filing or disclosure, and then claiming that those statements are misleading, deceptive, or omitted key information about the company's cybersecurity posture. Apart from negligence and those Consumer Protection Act claims, I'd say another frequent one we see is unjust enrichment. That is a claim that's often a throwaway, but plaintiffs make an argument that, well, if a company didn't spend the money they should have on data security, then they somehow got some windfall because of that. And so that's another claim we frequently see. And I'd say, Allison, going back to your point about the trajectory of these cases, I think once an entity goes out with notice, We're seeing suits filed within 24 hours if it's a particularly noteworthy notice that goes out that shows that a lot of people have been impacted and data that some folks consider more sensitive is impacted, but it can also take a few days, weeks, or even months for plaintiffs' lawyers to find clients to bring these suits. So again, there's some variation in there and the time frame for when the actual suit hits a court's docket.
One quick thing on that is what is interesting to Adam and I is we had clients a couple of years ago who would have a data incident and it would affect 100,000 people or 200,000 people. And we would tell those clients, there's not a huge litigation risk here because of the number of people that were impacted in your breach. And so to Adam's point, that's just not the case anymore. There is a group of plaintiffs that primarily only play in the big incident space, but then there's also a group of plaintiffs firms who have emerged to play in the medium-sized incident space. And then there's a group of plaintiffs firms that have emerged that play in the small data breach space. So to Adam's point, it's a key difference we've been telling our clients over the last couple of years. Litigation risk is no longer driven by how many people were impacted in your incident.
Those are all really good points. And I want to kind of maybe spend a couple of moments teasing out a few of those things because I think one of the things, Allison and Adam, you were both discussing is the relationship between the privacy-oriented laws and how these litigation matters are first presenting. And so, we were talking about notice. So I think in this context, for those who are not as familiar with this space, there are every state in the United States and countries around the world all have different forms of data breach notification statutes that would require an organization who's had a breach, an unauthorized access or acquisition of their information, to disclose to impacted individuals that their information has been compromised. And so that's going to be made public, right? We're going to be telling the outside world, individuals, and potentially to regulators, and in some cases, even to the media, that there has been a data breach. And what I hear you saying is that, okay, when you make that notification of a breach, you get a check mark next to your name, you satisfy that particular obligation, but the risk that you are facing is going to go on much longer than whatever it is that you were dealing with for that particular notice.
To be a little flippant about it, Scott, you not only put a check mark against your name, you put a bullseye on your name too. And that is really what we've seen, as Allison was mentioning, is the breadth of the plaintiff's bar that's focusing on these cases. They are trawling websites that post notice. Some of the regulators to which notices are sent have those publicly posted on their website, both at the state and federal level. And you better believe that plaintiffs' lawyers have dingers set up and are tracking those and seeing what entities are going out with notice, and then looking and investigating those to see if they can bring a viable claim against those. So totally agree with that. As you fulfill your obligations to complete notice, just know that you're also having a target on your back at the same time.
So what you're saying, Adam, is that in your experience, while there may be a handful of consumers that are particularly annoyed or aggrieved by having their information out there, the more likely scenario is that there are plaintiffs' law firms that are specifically targeting these types of events to form a group of impacted individuals for class actions or other type of litigation.
I think that's exactly right. And they're not terribly picky about what plaintiffs they choose to bring those actions. I think we're going to talk about class certification in a minute, which might be helpful when you actually get to class certification. But in some of the class actions we have pending now, it's paralegals in their firms or cousins of the plaintiff's lawyer or someone's son who are these plaintiffs. I think they're getting these cases in two ways, exactly how Adam is saying, finding these notices posted on the web and then going and trolling for plaintiffs who might have been impacted, or to the extent anyone they know received a notice letter, then bringing a suit on behalf of that person because they've got a live plaintiff in their hand.
Does it have to be somebody who actually received a notice, or are we seeing instances where people who actually receive a breach notification also bring a similar type of lawsuit?
I would say that those cases have fallen away. Adam and I have a client who was sued several dozen times a couple of years ago, and it became very clear very quickly that a number of those plaintiffs had not received a notice letter and were not impacted in those incidents. And those folks dismissed their claims pretty quickly. For another podcast, we can discuss some of the exposure some of our clients are seeing when there hasn't been a data breach at all. And plaintiffs are, as customers, are bringing claims about inadequate data security, but that's not what we're here to talk about today. So generally, yes, people have gotten a notice letter. They generally attach it as an exhibit to the complaint. And it's one thing we're really counseling our clients on recently is about how careful to be and what to say in the notice letter. Because if you are putting out into the world that certain data elements were impacted, and that's in the notice letter, even if those data elements were only impacted for one person and the rest of everybody else in your notice population only had less data impacted, your named plaintiff is going to attach that notice letter to their complaint and allege that every single data element that's in your notice letter was impacted for them and every other single person that was impacted in your incident.
Obviously, a practice point for when you're actually trying to address the compliance obligation of fulfilling these notices. Adam, maybe I can ask you just to circle back on a thing you were describing earlier, and that is the types of claims that plaintiffs are bringing. What I heard you say, negligence, unjust enrichment, right? Kind of a number of probably statutory and common law type of arguments that have existed for a very long time, well before there was ever digital data. But it sounds like now we're applying those standards. Is that it? Or are we just applying those old obligations? Or are there laws out there that specifically says, if you have a data breach, you owe this particular amount of money?
Yeah, it's kind of one of the classic scenarios of the law trying to keep up with the pace of technology and events in the world. And I think for a long time, plaintiffs were stuck with kind of old style common law and statutory claims and trying to repurpose those and apply them into the data breach context. Now, over the past few years, there have been a series of comprehensive privacy and data security laws that have been starting to pop up across the nation. But an interesting feature of those is almost all of them do not have what's called a private right of action. In other words, they can't be enforced through a private suit, and instead they're enforced through regulatory means. The notable exception there is California's statute, their privacy statute, which does have a private right of action for a breach of reasonable data security measures. And so that certainly has been used by plaintiffs over the last couple of years since that statute came into effect. And I'm sure that plaintiffs' lawyers would like to see more like the California statute get enacted across the country. But until then, they are having to repurpose some common law claims, even breach of contract as well, and some traditional statutory claims like consumer protection laws, and repurpose those in the data security context.
I think plaintiffs have gotten a little more savvy in the last couple of years, Scott, because they are starting to eliminate some of those common law claims that they have lost over and over in many of these suits. So, 2 or 3 years ago, you would see every single common law claim you could potentially bring in these suits, including a third-party beneficiary of a breach of contract claim, unjust enrichment, all of those. And in some cases that we see now, plaintiffs so every single complaint you got would be like 10 claims. In more recent cases we've seen lately, I would say many of those are pared back to 3 or 4 claims and having eliminated some of those that they've tended to lose on multiple times in different cases.
Maybe for both of you, going back to my law school days, one of the things that I think was quite clear, in order to have a court to provide a remedy, you not only need to, have some sort of claim, but you need to have damages. What are the damages that these plaintiff law firms are seeking?
Yeah, happy to start, Scott, on that one. So this is kind of an interesting feature of these particular cases, and that is plaintiffs throw a bit of a kitchen sink at the damages issue, and it spans everything from some types of out-of-pocket costs. So they say, I experienced identity theft and someone opened an account in my name, and through that account incurred various charges, not all of which were reimbursed. That's a form of damages. So you've got claims that are related to those kind of costs. But apart from that kind of core identity theft, data security type damages, plaintiffs have branched out and sought a host of other things, including an overpayment or benefit of the bargain theory of damages. So under this theory, plaintiffs say, I would not have patronized, purchased the product or service of the defendant entity that had the data security incident if I had known that they had bad data security. So you can envision this popping up in various scenarios, which it has. So you buy a pair of shoes at an online retailer, and that online retailer has a breach, and you say, I wouldn't have bought the shoes, or I would have paid less for the shoes if the entity had substandard data security, which we think they do. So that's another common one. In addition to that, plaintiffs have tried a variety or variations on a theme of my information is now less valuable or has less utility now that there has been a breach. We sometimes refer to this as the loss of value of PII theory of damages. And the kind of interesting thing about this mishmash of theories is that plaintiffs will emphasize certain ones at the beginning of the case to try to persuade a court that they have real damages that they're seeking. So they will emphasize, again, that kind of identity theft, lost, out-of-pocket cost type damages. But assuming they're able to get past the pleading stage and their case doesn't get kicked at the beginning, they will then quickly pivot to other theories of damages that are more advantageous to them as the case proceeds toward the class certification phase. So in that respect, you'll see them talk a lot about out-of-pocket costs and damages at the beginning of the case, and then quickly forget about that and then focus on benefit of the bargain and these loss of value of PII theories and future risk of harm theories of damages once they get past that, because those are more, again, helpful for them to try to certify a class.
So let's talk about that certification component, Adam, because I think this is an area where we're actually seeing a lot of interest. As you made the point that this is getting a certified class is, one of the necessary conditions for the plaintiffs' law firms to take interest in these types of cases, because they want that class to be large, in which case the dollars that are asked for go up. But this is also an area, I think that both of you said didn't exist maybe more than 10 years ago. Right. So we don't have the 100 years of common law that attach to negligence-oriented claims or attach to unjust enrichment or all of the various things that they're alleging in the data breach context. Instead, we're really developing the law as we go, including how courts think about certification for classes following a data incident. How is that analysis normally done by courts, and what do you see as the key requirements in order for a court to certify a class action data breach case?
So the basic contours of certification is common across class actions, whether you're in the products liability space or whether you're in the data breach space. And the key touchstone there is Federal Rule of Civil Procedure 23. And under Rule 23, there are two main components that plaintiffs would have to certify to have to be satisfied to certify a class. There's Rule 23A, and then there's Rule 23B. Under Rule 23A, there are a handful of requirements there, which are referred to as numerosity, commonality, typicality, and adequacy. And then under Rule 23B, the two key requirements there are referred to as predominance and superiority. So there are a lot of things that plaintiffs will have to do to tick all these Rule 23 boxes and to certify a class. Not surprisingly, some of those requirements are more onerous than others. And I think pretty consistent with class action practice in other areas of the law, a lot of the action for data breach class action litigation turns on a couple of those. In particular, the typicality requirement under Rule 23A and the predominance and superiority requirements under Rule 23B3 if plaintiffs are seeking damages.
Yeah, I totally agree, Adam. And I think, as you and I both know, frequently that typicality analysis and the predominance analysis ends up looking very, very similar. Because what the court is looking at is whether the named plaintiff can stand in the shoes as a representative for the putative class. Can we treat this person as the same as every other person that they are purporting to represent? And so under the typicality prong, what you're asking is this person's claims typical of that of the class? And then under the predominance prong, what you're asking is, well, are there going to be individual issues about the individuals in the class that are going to predominate over those common issues across the class? So you can see how arguing that a plaintiff is typical of everyone else, and also arguing that the issues that are related to that plaintiff are so common across everyone else that commonality predominates, how those arguments end up being very similar. Adam is spot on about Rule 23's analysis. One thing we've really started to focus on a little bit more is adequacy as well. So adequacy can be thought about in two ways. Is this named plaintiff adequate to represent the class? And are these plaintiff's attorneys adequate to represent the class? Most of the action on adequacy is related to the named plaintiff. And so earlier when I mentioned about, going out and finding your paralegal or finding your brother or whatever, you can absolutely make claims about why that person is not typical of the rest of the class and why there might be individual issues about that person that are going to predominate such that a class should not be certified. But we've started to explore during discovery, and Scott, to use your word earlier, another practice point is, Hogan Lovells feels very strongly in these cases that taking robust discovery of the named plaintiffs is important for just these reasons, to be able to determine whether they are an adequate representative, to be able to determine what individual issues exist for them. So just to add on a little bit of what Adam is saying there.
So, Allison, I want to piggyback on that, because what I hear you both saying is that, okay, we have an existing structure under which to analyze these types of claims, but what is unique is the specific facts, the specific circumstances under which we're having to evaluate it, using all of the existing criteria to do that. I think several years ago, there was a lot of debate in this sector, this particular area around standing, and whether there was proper standing for any individual to bring an action following a data breach. And that still may be an open question in some places. But I think what has happened most recently, and I'm interested in hearing about where we're starting to see updates, is that the courts have started to really scrutinize certification and have started to develop case law on that, including the Fourth Circuit. Allison, I'm interested in your perspectives. What was happening? I think that was the Marriott case recently.
Yeah, absolutely. Would love to talk about Marriott. And Scott, I think you've teed this up really well. We are starting to develop a real body of case law around the motion to dismiss phase, whether that be on standing or whether that be on 12b-6. But we have very little case law, essentially very, very little case law on the class certification phase. And so Marriott is a very interesting decision because it is one of the first early decisions from a court of appeals analyzing the district court's grant here of class certification. So why don't I tee up what happened in Marriott, and then Adam can get down into the weeds about why what happened. So in Marriott, which is a large MDL that was created after the Marriott data breach litigation, the district court there, and again, we could do a whole podcast on the district court's class certification decision in Marriott and the various ways in which he maneuvered the facts of that case to certify a class. But the district court did find that as to both Marriott and to Accenture, Marriott's vendor, that he could certify either a class or he could certify specific issues, even if he couldn't certify a claim as to that particular class. And Marriott and Accenture appealed those decisions because class certification decisions are appealable to the Fourth Circuit. And about 2 weeks ago, we got a decision from the Fourth Circuit reversing the class certification decisions, both as to Marriott and as to Accenture. And I'm hoping Adam will share with us why, because they were reversed for very different reasons. So I'm hoping he'll share quickly what those reasons were. And then I think it's especially interesting for the listeners to maybe have a further discussion about why the classes were, or the class was, issues were decertified as to Accenture.
Yeah, so the particulars in this one is the district court had certified a handful of classes for breach of contract and Consumer Protection Act claims under Rule 23b-3, which we covered just a few minutes ago, and had also certified 2 classes with respect to a negligence claim as issue classes. Now, this is kind of a weird, weedsy piece of Rule 23, which is that separate and apart from certifying classes, you can actually certify particular issues if the court determines that certifying an issue will drive a proper resolution and be more efficient. And so the district court here had held, you know what, I think there are certain pieces of a negligence class, issues with the negligence class, that can be certified as to Marriott's vendor Accenture. In particular, the court focused on whether or not that there was a duty for Accenture to protect and maintain data, and then whether Accenture had breached that duty. So those were the two key issues that the court certified there. And then separately, as I mentioned, there was the Rule 23b3 damages classes for breach of contract and Consumer Protection Act claims. So the Fourth Circuit's opinion kind of split its analysis into those two buckets. So as to the court's order certifying the 23b3 damages classes, the panel held that those had to be vacated and remanded because the district court erred in not considering whether or not the putative class members had signed a class action waiver. So the putative class in this case were Starwood Hotels guest members. And not surprisingly, as a member and guest of the hotels, you would sign some terms and conditions associated with your membership and in staying in a hotel. And one of those terms turned out to be a class action waiver. And so the district court had said, I can push that to the side because that's a merits issue, whether or not they sign this class action waiver and therefore wouldn't be able to bring a class action at all. And I can certify a class, and then we'll get to that later. And the panel said, not so fast. What you need to do is to look at this issue before class certification, because guess what? It's intrinsic to whether or not you can certify any class, not surprisingly, whether there's a class action waiver. And so the court didn't actually reach the merits of whether or not the class action waiver was enforceable and remanded that to the district court to consider in the first instance, but said that the district court had to do just that, determine whether or not the class action waiver was viable and preclusive and how it impacted the class certification analysis. And so the district court will have to sharpen its pencil on that piece. So that's the 23b3 bucket. On the issue class bucket, the court said, now that I've vacated and found that the court erred on the 23b3, that essentially requires me to also vacate and remand the issue classes the district court certified, because essential to the district court's analysis was the idea that I have damages classes certified, and therefore it is efficient and superior for issues classes to be certified as well. So basically, in the panel's view, by knocking out the 23b3 classes, it knocked out the justification for certifying the issue classes. And again, that's remanded to the district court to consider in the first instance.
And just to, Scott, give you some insight on why the court's decision as to the issue classes is particularly interesting for us and our clients, is we've seen plaintiffs more and more try to use issue classes and the certification of issue classes as some sort of hammer to wave around that they've gotten some sort of certification and therefore are in a stronger position. And as the Fourth Circuit said in their decision, eventually, if you narrow the case down to teeny tiny issues, you're going to be able to find that there are teeny tiny issues that are the same across the entire class. I mean, the three of us on this call, if we got narrow enough, that we could find things that are the exact same about us. But that's not what class actions are about. Class actions are about finding that the common issues are so big and important to the case, they predominate, such that class actions are the superior vehicle for moving the class forward. And finding that many, many, many little bitty issues are common across the class doesn't do that under Rule 23, which is why I think Adam and I feel that this particular decision is really helpful, because it avoids putting our clients in positions where plaintiffs' firms are just trying to pick around the edges with issue classes in an effort to gain additional leverage.
Yeah, that's interesting, Allison. And so as I think about what the broad implications are for both of the two issues that the Fourth Circuit has, I think somebody who is new to this space may say, okay, this is really highly technical. This seems like, what general principles could I draw from this case? And why is that going to be helpful in the event that I'm involved in a data breach lawsuit in the future? How would you think about that question?
Yeah, I'll take a shot at it. And then Adam, I would love to hear your thoughts on this, because I don't know that you and I have talked explicitly about this before. First and foremost, I think It forces clients to think about whether to enforce arbitration or class action waiver rights, which is something we're already advising clients on. It is a very complicated decision. And this is one piece on the side of the scale toward, yes, you should at least stop and have that complicated discussion and decision about whether to enforce those rights, because courts are clearly going to pay attention to them before certifying classes. And then as to the issue classes, I'm not sure that it changes the analysis for our clients very much, but I definitely think it changes the way that we as lawyers approach discussions with plaintiffs and approach discovery, and making sure that we focus on the big issues. We focus on the big issues in discovery, and we don't let the plaintiffs reframe the debates to tiny red herrings, in my opinion, and instead force the entire conversation in discovery and in front of the court on class certification to be on the big issues about the breach and about whatever alleged harm plaintiffs say that they have suffered. Adam, do you have other thoughts?
I think you hit the two really key takeaways there. The only other thought I'd add is on the first one, in terms of the decision about whether or not to enforce arbitration and class action waiver rights, is just a timing issue. In the Marriott decision, interestingly, the plaintiffs, after the decision was issued, said, "Oh, this is great. We're really excited to show why Marriott has waived its class action waiver rights by sitting on them for so long, and we think we're going to prevail." And that just gives you a window into the issue. Not only is it important to think hard about whether or not to enforce your rights, you also have to think about when you do that, because class action waiver and arbitration rights are something that courts require defendants to assert on the early side in litigation. And if you sit on your hands and wait until the very, very end, a court is more likely to find that you've waived those rights and they're no longer enforceable. So not only should you think long and hard about it, you should think about it, unfortunately, at the very beginning of the case. Otherwise, you could be in a position where even if you wanted to assert them, you would be precluded from doing so because you waited too long.
So thank you, Adam and Allison. This has been a really fascinating conversation. I think it really provides a great overview of where we are with cyber litigation at the moment. Maybe just switching gears slightly, what is unique about both of your practices is that you not only counsel clients on how to respond to a data breach case and to manage litigation related issues, but you also work with clients to try to avoid litigation from the very beginning, in the event that they are sued, to put them in the best position to effectively have those cases dismissed very quickly and with the least amount of pain and expense. So, Adam, maybe I can start with you. Let's maybe for a moment imagine that you are in-house counsel who is working with a large global client with significant data-related assets. What kind of things are you going to help your business to try to manage these things? I know there's many things to do, but maybe just focus on one that kind of sticks out in your mind.
Sure, happy to take a shot at that, Scott. So one of the things that Allison and I and others on our teams spend a lot of time helping clients with is to think about how you want to set up your incident response processes on the front end before an incident happens. One of the things we've seen, having gone in the trenches in these cases and litigating them, is that plaintiffs will try to zero in on some of the core after the fact communications that happen when the company's trying to figure out what's going on, what happened, why did this incident occur, and are looking to get kind of candid and clear advice both from its own internal stakeholders and from any third-party vendors that are helping them to do that. So it's this kind of unfortunate situation where a company is getting penalized, or plaintiffs are trying to penalize a company for having those candid conversations in the wake of an incident to, again, try to figure out what happened. And so one of the things we often advise clients on to address that issue is to set up agreements in a way that fosters that candid conversations and that protects them down the road should there be discovery. Because again, we want to facilitate the client's ability to get that advice and to be able to act on it in a very quick and timely fashion and not worry about getting second guessed down the road. And to do that, one of the things we work with clients on is to set up their arrangements with forensic investigators and other key third parties that come in after an incident, to set those up in a way that facilitates the provision of key advice that goes into the assessment of legal risk. And so that is, I think, one of the key things as an in-house lawyer to kind of have in the back of your mind, if you haven't already, is how do we think about these third-party forensic investigators and other vendors we have that we know we need in the event an incident hits, and how can we set them up in a way that enables us to, again, keep the information flowing in a way that protects us from litigation risk down the road.
And I know that's even an evolving kind of set of standards to make sure that you're meeting, so you're protecting those type of information. That's a really good point, Adam. Maybe Allison, interested in your perspectives on that same question. One tip that you would immediately try to implement if you were in-house counsel.
Yeah, absolutely. I think one thing that Adam and I have learned through working with a lot of companies is in the fog of an incident, everyone on the ground feels like their stakeholders are the most important stakeholders. So whether that be comms, or whether that be your PR people, or whether that be business folks, or whether that be legal, everyone believes that their stakeholders are the most important stakeholders. And as a result, sometimes you have people within the company going out with all sorts of statements that may or may not be grounded in the facts of the incident, and may also be overstating various pieces of the incident. I mentioned earlier about the notice letter and how critically important it is that the notice letter be as precise and thoughtful as possible, because it's going to be attached to the complaint. And so you want it to be precise, because that is the facts of the incident. We want to be precise about the facts of the incident. And it's the same with communications. And so I think one thing that we see with companies who handle incidents really well as it relates to litigation risk is that there is a gatekeeper of information, and that gatekeeper is making sure that everything that leaves the company is factual and that we are being as precise in our communications as possible. And while that has, I think, traditionally been thought as a core incident response issue, and it also has profound impacts on what is said in the complaint about you and in what things happen in litigation discovery after the incident.
Yeah, excellent point. Well, I think we will leave it there. And so, Adam, Allison, thanks so much for joining the podcast. Hopefully you will rejoin us on another day. We'll dig further into these issues, but really enjoyed today's conversation and certainly learned a lot. With that, this is the Data Chronicles. I am Scott Loughlin, and those are your data points.